Hello everyone. So today in the IRL, we are going to study about the procedure for settlement of dispute as per the Industrial Dispute Act of 1947. So to start with, let us discuss what is a conciliation. Conciliation is a voluntary process in which a professional facilitator assists the employer and employees to resolve the disputes when their own unassisted efforts have not succeeded. The process can be described as a facilitated search for agreement between disputing parties. And how does it work? The Workplace Relation Commission assigns a conciliator known as an Industrial Relations Officer IRO who acts as an independent, impartial chairperson in discussion and negotiation teams. The, the task of IRO is to assist the parties in their effort to reach a mutually acceptable settlement to their disputes. Who can use the service? The service is available to all the employees and employers except those specifically excluded by the law. However, even in these cases, the service may be made available on an ad hoc basis where all the parties request assistance and where such facilitation can be accommodated. What are the types of dispute that can be referred in the conciliation? So, the claims for improvement in pay or conditions of the employees in an organization. The disciplinary cases in which the employees are demanded to follow a certain pattern or a format to be in an organization. Grading issues and disputes arising from the proposed changes to the way work is done. Like there will be a specific format of work pattern in which the employees have to work. Companies restructuring. If any renovations or the policies, terms are changing in the company, the employees have to adopt the same. Who can use the services? The service is available to all the employees and employers except those who are specifically excluded by the law. However, even in these cases, the service may be made available on an ad hoc basis where all the parties request assistance and where such facilitation can be accommodated. So, who is a conciliator? The conciliator is an industrial relation officer. He is an officer at the Workplace of Relation Commission. All the IROs come from an independent public service background. They are trained and experienced experts in meditation and conciliation techniques. So, who controls this conciliation process? The employer and employee representative retain control of the issue in dispute during the conciliation process. The Workplace Relation Commission never imposes an outcome on them. Settlements of a dispute is an outcome that the parties themselves voluntarily decide. Likewise, where the parties do not resolve the dispute at the conciliation, that is also their decision. How do I begin a conciliation process? So, the process of conciliation begins when one or all the disputing parties write to the Workplace Relations Commission requesting an assistance in resolving their industrial relation disputes. The Commission responds to positively to such request and contacts all the parties in order to confirm that they wish to attend at conciliations. The arrangements for the conciliation meetings are finalized only when all the parties confirm their willingness to participate in the process. And what is the outcome from this conciliation? There are two possible outcomes to the conciliation process. The first one is resolution of the dispute or continuing disagreement. A settlement occurs either when the parties themselves reach a mutually acceptable agreement in the conciliation or where they accept a proposal for settlement that the IRO has to put on them. The industrial regulation officer will usually only make a proposal when he or she is satisfied that the negotiation terms teams will recommend its acceptance. If he does not impose a proposal on the parties, it means that he may also adjourn the proceeding to allow the parties consider their positions, such as the board of conciliation, the higher authorities who can decide on the proposals. A board consists of an independent chairman and two or four other members who represent the parties to the dispute. The board that conducts the conciliation procedure in the same as the conciliation officer. The board is, however, expected to submit report within 2 months of the date on which the dispute was referred. So, apart from the conciliation officer, that is industrial regulation officer, only top level authority members have the right to conduct the conciliation process and also have a time of 2 months within which they have to submit a report on the disputes which were referred on the dates. So now the next term is arbitration. The term arbitration refers to the settlement of an industrial dispute between the two parties by means of a decision of an impartial body when efforts at conciliation have failed. In conciliation, the wishes or point of view of the parties are very important, and an agreement is to be arrived at there in the accordance with their wishes. But in voluntary arbitration, thus in the arbitrator is appointed by the parties through the mutual consent, but the arbitrator acts as the dispute is to refer to him, which means if the arbitration is done, the parties try to make a decision or an agreement where both of them can conclude with their wishes. But in a voluntary arbitration, the member who has been appointed as a conciliator, he will impose the decision and both the parties have to obey without mutual consent. What are the main ingredients of voluntary arbitration? The industrial disputes must exist. The agreement must be in writing and not in an oral form. The reference to voluntary arbitration must be made before a dispute which has been referred to under Section 10 to a labor court, tribunal, or national tribunal. The name of the arbitrator must be clearly specified, and the arbitrator must investigate the dispute and submit the appropriate government the arbitration award, which is signed by the arbitrator. Thank you so much for listening.